Trial by jury was a rallying call during the American Revolution. It has been called one of the great bulwarks of liberty in the Anglo-American tradition. But the jury's historical origins had little to do with liberty, and its medieval role was far removed from its modern role. Most remarkably, its modern role is the result of two contradictory narratives. First, it is the story of the jury's rise to independence. In this story, we will see a trajectory whereby the jury gains independence from the bench. This is a story in which the narrative arc stretches from the 15th through the 17th century. But there is a counter-narrative. This counter-narrative is that of the jury's prominence in primitive systems of law and its the curbing of its authority as systems of law become more sophisticated. And we will see, if we go back to England and we stretch the timeline back to the 12th century and look at the powerful jury as it existed in the medieval era, we will see that from then till now, its power slowly gets impinged upon. And we see the same thing, by the way, in America as well. The juries of the 17th and 18th century had remarkably more power than do juries of today. Now, to understand this historically, I think it's a good idea to go back and look at the medieval story of the jury. So the medieval jury served several purposes. Two of its most prominent were that of inquest and as a mode of trial. These are two processes that lie at either end of the legal process. If we go back to the 12th century, we see the English kings extending royal justice by means of the assize courts. These were circuit courts, traveling justices who went from county to county. But in the 12th century, there were no king's attorneys, no police, no Scotland Yard. So who exactly did the king's justices prosecute? In the Assize of Clarendon of 1166, Henry II ordered that the royal justices would convene in every shire, and that through 12 of the more lawful men, an inquest would be made, and, quote, murderers and robbers, end quote, would be presented to the justices. Although the Assize of Clarendon, and assize in this case means a legal order given by the king and council while at Clarendon, does not mean does not name the 12 lawful men as a jury, one can see that this is an early predecessor to a grand jury or to a presentment jury. The other kind of jury was the trial jury. The common law proceeded before justices and by specific writs. We've talked about this on several occasions. But you got to remember that the common law process that is developed in the 12th, 13th, and 14th centuries did develop according to these very specific systems in which you have this very specific writ. And if you think about this from start to finish, you would have to initiate an action as a litigant. That means you would go to the chancery and you would purchase a writ. You would have to make sure, of course, that you purchased the proper writ. Each writ then came with a procedure. The first part had to do with making your adversary appear. You could do this by pledge or by gage. You could have him put under attachment or under subpoena. I mean, there were various ways to force your adversary to come before the court and answer your claims. Then you would get the pleadings. The pleadings are all legal. They have to do with the specific form of the writ, and so they are different for each writ. Now, if the pleadings do not resolve the case, in other words, if the case is not resolved during the pleading stage, then you must go to mode of trial. And when you actually have a trial, that's when you're going to put the question before some means of resolving it, which in the end will be some mode of proof, some way of finding proof. The final step in common law procedure is, of course, the execution of judgment. And by the way, each of these stages actually involves the issuance of various kinds of writs, and it still does today. You have orders and motions before the court that would approximate the kinds of writ action that we see in the 13th, 14th, and 15th centuries. But notice here, this is where the trial jury actually comes in. The jury, or rather the idea that you needed to find some mode of trial in order to resolve an issue that would not be resolved by the two parties leads to a variety of different kinds of modes of trial. We've talked about ordeals. Ordeals was a very common one. There's also other ones that are specific to specific kinds of law. So for the writ of debt, for instance, wager of law was the preferred mode of trial. It becomes the only one later on. There was battle. You could have a battle resolution, and jury was another. Now, ordeal, by the way, was traditionally the most common, but the Catholic Church abolished ordeals in 1220. And they abolish ordeals, or once they abolish ordeals, the jury starts to step up and take a prominent place in the English legal system. And the inavailability of the ordeal had a lot to do with the rise of the jury as a preferred mode of trial. And one thing that's important to understand about this early jury, the medieval juries, is that they are self-informing. That is members are chosen because they know the parties, because they know the victim, they know the accused, they know the litigant, they know the defendant. They knew what happened in a lot of cases. In other words, the jury was expected to know a lot about the case that was before it and about the character of the people who were being presented. So this is what we call a self-informing jury. And the trial jury, of course, would ultimately be resolved at the number 12, but there were lots of different sized juries. There were juries of 6 in some cases. There were juries of 24. There were juries even of larger numbers. Inquest juries sometimes got up to, well, I can't say for sure, but I believe inquest juries get up to be quite large, over 40 in some cases. Now, this, by the way, reinforces the importance of the jury as a local institution, not an institution like a common law court that has its own procedures, that has an institutional history, a writ system, a professionalized bureaucracy that keeps it going. Juries are spontaneously popping up, but they are the same in this sense. They are leaders of the community. They are people who are selected because the king trusts these people. The king's justices trust these people. And in this way, they reinforce the king's power at the same time that the king reinforces their power and their status. The two are essentially rising in stature together. But this would come into conflict with the common law, and in particular, not just the 3 central courts, but as the assize justices became more and more formalized, as the king's justices became more and more learned, they began to resent the fact that juries had so much power, and they really do have a lot of power. There is this problem of the unimpeachable jury, the idea that their verdict, once decided, was sacrosanct. It was over. It could not be looked into. The judge essentially had no power to reverse a jury's verdict. And so in the medieval era, if we go back to the early medieval era, the jury is enormously powerful. But the unimpeachable jury, the unimpeachable verdict of a jury was in fact not unimpeachable. And if we look at the 13th, 14th, 15th, 16th, 17th centuries, we start to see increasingly judges taking control of cases. First of all, as judges professionalize, as they learn the common law, they instruct jurors. And so you start to see, particularly by the 13th and 14th century, juries are essentially being told what verdict to bring in. They're being told, well, you have to decide X, Y, and Z. You decide these things, and if you decide in this way, then you must rule for this person. And so judges began instructing jurors. They began exercising a lot more power over them than they had in the past. Now, this didn't mean, of course, that jurors couldn't go against what a judge said, but if a juror did, there were certain ways to challenge a jury verdict. The most ancient was the writ of attaint. And this was essentially a motion to quash in modern language. But the writ specifically states that if the jury gives a false verdict, then the writ can be employed. And it carries with it criminal penalties for the jurors. As such, jurors accused of attaint could find themselves before a jury of 24, this is what the jury of attaint called for, who would judge them. It was an extreme action to sue out a writ of attaint, and as such it was not frequently resorted to. It is, however, resorted to. I mean, even though I say it's not frequently resorted to, we have dramatic instances of it being brought up in the 15th and 16th centuries. By the 18th century, it was archaic and it had fallen into disuse. There's also the writ of error, and a writ of error could overturn a jury verdict, but only indirectly. Remember, the writ of error is a bench writ. It's issued by a superior court to review and correct errors in the proceedings of an inferior court. I discussed this in week 2 in the lectures in there about the medieval heritage of the common law. So if the evidence and verdict, which are not part of a record of the trial, are not actually looked at through the writ of error, the record that the writ of error is correcting is the writs filed, the answers made, and the pleading that took place. In short, the record is all law and no facts. All law and no facts. And I hope I've made that distinction clear. I'll just go ahead and repeat it. The evidence and the verdict are not part of the legal record. The record that the writ of error considers is solely the writs filed, the answers made, and the pleading that took place. That's the law. And so what the judges, the superior courts do when they review the record is essentially they could reverse for a legal error. And if they do so, they could in essence overturn a jury verdict. But we have to remember that it's really indirectly here. They're not overturning the verdict itself. They're saying there's an error in law, and as a consequence, the jury verdict is in essence nullified. There was a much more effective way to do this. I hope you remember the Court of Star Chamber. This is the court that's created out of the King's Council by Henry VII in the 16th century. And it was the same court that would be used so tyrannically by Charles I that it was forever associated with absolutism and tyranny. Well, before it got that reputation, one of the things that it did was it would investigate corrupt juries. If a judge suspected a jury of corruption because it, quote, decided against the evidence, end quote, then it could bind the jury over to Star Chamber, which would investigate. Star Chamber became a kind of regulatory body that could discipline corrupt jurors for bribery or dishonesty. And unlike the writ of attaint notice, Star Chamber is staffed by the counselors themselves. So this was a conciliar court that could exercise conciliar authority without the intervention of another jury. It's not clear from the records how many jurors were fined or imprisoned by Star Chamber. Some writers, contemporary writers, claim that fining jurors was very, very rare. Others claim that scarcely a judicial term went by that judges were not bound over to Star Chamber. In either case, Star Chamber was abolished in 1641. And this, of course, means that it will not be available to bind over and fine jurors. But that has become standard practice, or I shouldn't say necessarily standard practice, but it has become a practice with Star Chamber, leading many to wonder if jurors could be fined and bound over by common law courts. Now, we need to think of a few things here about the physical space that juries occupy and about the way that they work in the medieval era. In smaller courtrooms, juries often deliberated in the same room as the judges, maybe off in the corner. If jurors needed to deliberate elsewhere, they were essentially locked up and kept without food and water or a toilet until they came to a unanimous verdict. Perhaps it is not surprising that by the 17th century, jury verdicts were turned in within minutes of the judge's instructions to the jury. And jurors, by the way, describe themselves as prisoners of the court during this time. So quite frequently, they will be called upon to issue their verdicts, and they will be taken and watched over while they deliberate, and they will be kept without any food or water or drink. And when they come back, they essentially just agree to get it out. And there's some evidence that jury verdicts are returned literally within 3 minutes. So that's the average return for a verdict during this time. So you can start to question by the 17th century this idea of the jury as a bulwark of liberty, at least in general. So how should we think about the jury in the 17th century? It had been freed from Star Chamber after 1641, but as I pointed out, in many ways it was still a prisoner of the court. As an institution, it did not have the broad powers that it had had in the medieval era, when it acted as a modern-day attorney general would, bringing indictments and making accusations and being a motive proof beyond which there was little resort. one watching a trial would probably not think that a jury was accorded much respect. Certainly, when the verdict that the judge told the jury to come to, they came to within minutes of his telling. The jury is still integral, and jurors could still make their weight felt. And to get to this, we want to consider the story of William Penn and William Meade. The Penn in this case is none other than William Penn, and not this William Penn. This is William Penn Sr., Admiral William Penn, a courtier, very powerful, under both Charles the First and Second, and actually survived the Commonwealth as well. It's his son that we are interested in this case, William Penn as well. And this William Penn, of course, is the William Penn who founds Pennsylvania. Now, William Penn Jr. converted to Quakerism, something which, by the way, beguiled his father. His father was very, very, very upset with him for this. But William Penn had his father's wealth. He also had many wealthy Quaker friends, and he had a lot of devotion to the Quaker religion and the Quaker cause. He was a man of influence, but he, being a Quaker, was also an outsider. Remember, Quakers were pietists and dissenters. They existed outside the established Anglican Church. After 1665, thanks to the set of laws known collectively as the Clarendon Code, dissenters were not allowed to hold office, and they are otherwise discriminated against. And this is the story that occurs in 1670 that I'm about to tell you. Well, it's a very remarkable story, but it tells us a lot, not just about the jury, but also about William Penn and about the modus operandi of his settlement in Pennsylvania. In 1670, authorities closed the Quaker Meeting House on Gracechurch Street in London. William Penn and William Meade, two Quakers who were members, went to the street and began to preach there. The authorities arrested them, tried them with riot, unlawful assembly, and breaching the peace. Now, William Penn was not a docile Quaker. He was tried in the Old Bailey in London, and he made a scene there. His trial occurred before no fewer than 10 magistrates, including the Lord Mayor and the Aldermen of London. Both William Penn and William Meade proved truculent. When questioned by the magistrates, they frequently refused to answer, saying that they had a right not to incriminate themselves. They spent the entire first part of the trial demanding to, quote, this is the words of William Penn, know by what law it is you prosecute me, and upon what law you ground my indictment. The Recorder of London replied, upon the common law. William Penn, where is that common law? Recorder, you must not think that I am able to run so many years and over so many adjudged cases which we call common law to answer your curiosity. Penn, this answer, I am sure, is very short of my question, for if it be common, it should not be so hard to produce. This happens, by the way, on several occasions. William Penn and William Meade first refuse to plead to the indictment. They demand to hear the indictment. They demand to see the law. The recorder, by the way, is not amused. He demands, and I should make clear here, I'm sorry I didn't do this before, the Recorder of London, that's just another word for judge. So the recorder in this case is the Judge of London. The recorder, by the way, was not amused by any of this. He demanded that Penn plead properly. Penn retorted that the indictment had no foundation in law. You were a saucy fellow, said the recorder, and so it went on. The recorder told Penn and Meade to quit trying the patience of the court. Penn and Meade then both addressed the jury over the head of the recorder. William Meade, you, men of the jury, who are my judges, if the recorder will not tell you what makes a riot, rout, or lawful assembly, then I will. The recorder was now, by the way, very mad. He sent the two men away. This happens on several occasions, and he finally takes the two men to the bail dock, which is the holding place for the prisoners. And then the recorder charged the jury. So here he's taken the prisoners away from the bar into the dock. He says to the jury, you have heard what the indictment is. It is for preaching to the people and drawing a tumultuous company after them. And he was speaking. And if they not be disturbed, you see they will go on. There are 3 or 4 witnesses that have proved this, that he did preach there, that Mr. Meade did allow of it. After this, you have heard by substantial witnesses is set against them. Now we are upon the matter of fact, which you are to keep to and observe, as what hath been fully sworn at your peril. And then he sent the jury to deliberate. 8 of them returned. They said they all agreed on a verdict of guilty, but the other 4 refused to assent to the verdict. The recorder, very angrily, called all of the jurors back in and told them that he would mark them and do them great harm if they did not deliberate and come to a unanimous verdict. And so they went back. They deliberated, and then they returned with a unanimous verdict. You are agreed? Asked the recorder. Yes. Who shall speak for you? Our foreman. Look upon the prisoners at the bar. How say you? Is William Penn guilty of the matter wherefore he stands indicted in manner and form, or not guilty? Guilty of speaking in Grace Church Street, comes the reply. Is that all? That is all I have in commission, the recorder. You had as good say nothing, which just means you might as well not have said anything at all. But that's what the jury said. Essentially what the jury did was say, we find them guilty of speaking, but we don't find them guilty of unlawful assembly, or of riot. And so the recorder fined each of the jurors 40 marks and ordered them imprisoned until they paid for it, for, quote, finding a verdict contrary to law of this realm of England, contrary to the full and manifest evidence, and contrary to the direction of the court on a matter of law. Simeon Bushel, one of the jurors, sued out a writ of habeas corpus protesting his imprisonment. This went to King's Bench, which decided that the imprisonment was illegal. Judges may tell jurors the law, reasoned the Chief Justice, Sir John Vaughan, but jurors determine the facts. The jurors' determination of the facts was absolute. Of course, if the jury was corrupt, then the ancient writ of attaint lay. But the judge could not simply fine and imprison the jury to get his way, or because he disagreed with their verdict. Bushel's case established a distinction which persists to the present day, that judges determine the law, but juries determine facts. But there is another part to the Penn and Mead case that goes beyond this. Both Penn and Mead disputed the judge's interpretation of the law and appealed to the jury over the judge's head. This suggested that they wanted the jury to nullify the judge's interpretation of the law. Could not this go further? As you read the trial of Peter Zenger, think about precisely what the lawyers there asked the jury to do, and how the jury represented one of many different loci of power in the imperial colonial political system. And we're going to want to think about this as we continue, because juries do not remain static in either England or in America. They will change, their role will change, their position in society will change, and even our belief in them as a bulwark of liberty will change over time.